this video, we're going to give you a brief overview of what typically happens at an impartial hearing regarding your child's special education program. This kind of hearing is also known as a due process hearing. So first, what does it even mean to have a hearing? Well, it's a chance to be heard by a judge, who in this kind of case is formally known as an impartial hearing officer. At a special education impartial hearing, a parent and a school district will take turns presenting evidence and arguments to the hearing officer regarding a disagreement they have about a student's special education, and the hearing officer will issue a final decision to resolve the disagreement. This is very similar to a court trial, but actually it takes place at an impartial hearing office, not a courtroom, so it's not as formal. The hearing process often varies depending on your child's individual circumstances, the kind of issues you're raising, and also the hearing officer assigned. Usually the first step is a pre-hearing conference, which typically takes place over the phone with the impartial hearing officer, the parent representative, and the school district representative. At the pre-hearing conference, we typically go over the issues in the case and set some expectations for how the hearing will move forward, including discussing potential hearing dates or the type of evidence each side intends to present. In between the pre-hearing conference and the hearing, we might schedule what are known as status conferences, where both sides will meet to discuss the status of the case. Maybe we're negotiating and could come to a settlement, or maybe we need more time to get some evidence. These are the kinds of things we discuss at a status conference before moving forward to the final hearing. Although parents aren't required to have an attorney to request a hearing, hopefully you are represented by an attorney to help guide you through this process. So let's say your attorney filed a complaint against your school district on your behalf regarding your child's special education, and your attorney tells you, "We're going to hearing." What should you expect the day of the hearing? First, let's talk about who's going to be there. If you're represented by an attorney, your parent attorney will definitely be there. As the parent, you can and should be there, though you don't always have to be. Then there's going to be a school district hearing representative, who's usually an attorney. There might also be a school district administrator in attendance, such as the director of special education. There's also going to be a court reporter. This is the person who's in charge of recording the whole proceeding and putting together a transcript of every word that's said. And of course, as we've mentioned, there's going to be an impartial hearing officer, who's an attorney who essentially serves as the judge for the case. They're called impartial because they're not employed by the school district, so they can give an independent look at the issues. In a case where a parent's primary language is not English, the parent can request that an interpreter be present at the hearing and provide word-for-word translation of the entire hearing. Now, what happens at the impartial hearing? At the start of the hearing officer is first going to review the document evidence that each side submitted and determine whether each document will be admitted into evidence. The parent and the school district should have exchanged their evidence packets at least 5 business days before the hearing, so hopefully there aren't any surprises here. If there's a document that either side believes should not be admitted into evidence and should not be considered by the hearing officer, then they can raise an objection, and the hearing officer can make a decision on that. After all the document evidence is admitted, the school district gives an opening statement where they explain their position and summarize their arguments. Then the parent side does the same. In New York, even if it's the parent who filed the complaint, it is the school district who needs to prove that they've been providing an appropriate education. So after the opening statements, the school district gets the chance to call any witness to testify at the hearing to defend the program that they've created for the student. This might be teachers, therapists, or school administrators. The parent's attorney has the opportunity to ask those witnesses questions to try to pick apart their testimony. Maybe the witness doesn't remember something as well as they claim they do, or maybe there's clarifying information that they're withholding. The parent's attorney can question the witness to try to get them to admit certain facts. After the school district's witnesses finish testifying, the parent's attorney then has the opportunity to present their own witnesses to testify, including the parent themselves, and we go through that same process of questioning for each witness. At this point, after the testimony, the evidence for the hearing should be complete, and the parties decide whether they'll make closing statements orally right there during the hearing, or whether each side is going to take some time to submit a written closing statement or brief. This might be needed in some more complicated cases to give the hearing officer a written summary of the arguments and the evidence that supports it. And then, all that's left to do is wait for the final written decision from the impartial hearing officer. Hope this video helped you learn a little bit more about what the impartial hearing process generally looks like, and if you're interested in learning more about special education law, keep an eye out for our next video.